Yes.
My lords and ladies, I appear on behalf of the appellant together with Mr. Thomas, and Mr. Pennington-Benton appears on behalf of the respondent. I think he's got something to say about Mr. Gowdy's position, Guthrie's position today. Yes.
Yes, thank you, my lords and my ladies. So, James Guthrie, it transpires, unbeknown to him, had some involvement in Mr. Saunders' case many years ago. In particular, I think some documents or an email was sent to him in 2003, which he then passed on to Julia Oury of Oury Clark Solicitors. Secondly, he's also stuck in a trial in the Bahamas, so for two reasons.
We're very grateful to have you here.
Well, that's very, very nice of you to say so.
Our good wishes.
Thank you.
Well, my lord, we appear instructed by Mr. Jabber of Simons, Muirhead and Burton, and they were asked by the court to take this matter on. We understand sometime after the appellant had submitted his own grounds.
Yes.
This is an appeal with the leave of the board and Her Majesty, granted on the 14th of March of 2018. The document pertaining to that is at page 477 of your bundle. The appellant appeals against his conviction for rape, which occurred in the Supreme Court of the Bahamas as long ago as the 15th of October of 1996. And he was convicted of the rape of Jacqueline Sneddon McCutcheon, which occurred some 3 years prior, on the 22nd of June of 1993, and he was sentenced to 14 years imprisonment to run consecutive to a sentence of some 25 years, which had already been imposed upon him. The grounds upon which he's been granted leave, my lords and ladies, relate solely to the handling of the issues surrounding the central evidence against him at his trial, namely that of the DNA samples and analysis which was done at that trial. My lord, can I just very briefly deal with the issue of delay here?
Yes, we've been sent a helpful chronology.
Yes.
And can I say I'm very grateful for your instructions, and indeed for you both for taking on providing such help as you can.
It seems a bit of a muddle, but the appellant certainly initially appealed his conviction and his sentence. On the day after his conviction, that's on the 16th of October, and that's in the electronic bundle at page 359 to 60, to the Court of Appeal of the Bahamas. But this appears to have been rejected as early as the 7th of October of 1997, and that's in page 361 of the electronic bundle. It appears, though, that left outstanding was an issue as to whether the appellant should have been given credit for his remand time upon this sentence.
We don't know anything about the appeal, do we?
No, we don't.
Whether he was represented,
we know not, but all we can say is that that issue, namely the remand time, was not dealt with until the 11th of February of 2016, and that's in your electronic bundle at page 362 to 363. And it was dealt with in a short judgment by the President of the Court of Appeal, Dame Anita Allen, with two justices. And some 6 months after the start of the service of this sentence for this matter, that was apparently on the 27th of July of 2015, according to the Court of Appeal's judgment. In other words, that would be when the sentence of 25 years expired, although the appellant himself expressed this sentence as having commenced on the 27th of May 2012, and that's in the electronic bundle at page 383. But what we can say, my lord, is that the appellant filed his grounds on the 20th of March of 2015. They were extensive and numerous. They're at the electronic bundle at 365 to 404. And having considered them, this court advised Her Majesty to grant leave on grounds 4, 6, and 7, paras 33 to 35 and 37 of ground 8. So 4, 6, 7, and 8 in part. And the leave document is in the electronic bundle at page 447. The core point in our case is in effect submission and ground 4, a failure of disclosure in connection with the core aspect of this case, namely the DNA. And perhaps I can start just with an overview of the trial process. The DNA evidence in this case was recovered from a tissue seized the morning after the alleged rape from an area believed to have been the scene of the start of the rape. The victim, Jacqueline Snedder McCutcheon, contended she'd been raped at this location, and her rapist, who she could never identify, throughout a process of some hours was with him and never was able to identify. She claimed had ejaculated on her leg and used a tissue to wipe off effectively the ejaculant. And
we have all that set out in very helpful detail in the agreed statement of facts.
Yes, and her evidence on this is page 60 of the bundle, lines 4 to 29.
There's no dispute about that. I mean, on
no.
paragraph 14 of the agreed statement.
Yes, my lord, yes. And the next morning, the tissue was recovered from Woodland by 2 police constables at electronic bundle page 120, when accompanied by the victim and her husband, and the purported finding of the defendant's DNA on this tissue, together with some of the victim's DNA, was not only the only piece of evidence to connect your appellant to this crime, but on its face was inevitably also compelling evidence of him having been the rapist. So, what of the trial process? What is clear from the record is that the appellant's trial upon this matter was brought on at short notice. The trial itself...
Forgive me, before we get to the trial, there was an old-style committal.
Absolutely, there was. There was an old-style committal beforehand, but the trial process, and can I deal with the trial process, and then of course, there was an old-style committal beforehand in which witnesses were called. There's no doubt about that. But the trial process itself came on at short notice. It started on Monday, the 8th of October of 1996. Apparently brought into the list on the previous Wednesday, and I get that from the submissions of Mr. Munro on the morning of the second day of the trial. And when he appeared to make an application to adjourn it, which was refused. Mr. Munro, on the second day of the trial, and his submissions effectively are electronic bundle page 48 to 52, made clear that the appellant's father had been trying to and had not obtained counsel for the appellant for the first day of his trial. And therefore the appellant had represented himself on day 1 of his trial.
Which page was this, you said, for?
This is Munro's submissions are the electronic bundle, page 48 to 52.
Yeah. Thank you.
He turns up and he makes submissions. He himself appears to have been doing a trial in an adjoining court, and he turns up, and his point is that it having only been listed on the Wednesday, even had he been instructed in detail before, it would have been impossible to be ready for the trial at that short notice.
But he doesn't say anything about the failure to provide the DNA samples.
He doesn't say anything about the DNA samples at all. The appellant therefore represented himself on day 1 of his trial.
I mean, it would have been an obvious reason for an adjournment if they'd been wanting DNA samples and hadn't got them.
Well, the appellant does make it absolutely clear. And I think what is necessary is to actually understand the vigour with which the judge was refusing to adjourn these proceedings and the statements which were made by the appellant at the start of the proceedings. It's very, very clear from that Monday morning that the trial judge is determined that this trial should proceed. And the appellant on that first morning is obviously prepared to take a point which formed part of his grounds of appeal before this court, on which he's been refused leave. And that point was the one about the invalidity of his committal. And the point, in effect, he was taking was that the justice appeared on the face of the record to have committed him before giving him the opportunity to call witnesses, and that therefore his committal was a nullity. And the judge took the view that the record showed quite the contrary, and therefore dismissed that ground. And after he had argued that, he applied for an adjournment to instruct counsel. That argument by the appellant was made in the presence of the whole jury panel at the instance of the prosecution, an unusual course. His application for an adjournment was made in the presence of the jury panel. Again, something of an unusual course. And the trial judge insisted on the jury being sworn. And not only at that, but at an electronic bundle, page 36, when the defendant says he needs an adjournment to get his witnesses, and he names the 18 witnesses who he had named, as I understand it, in the committal proceedings, the trial judge insists that he name all of those 18 witnesses in front of the jury, which he duly does, and one can see them at line 21 to 31 of page 36 of the electronic bundle listed there. The judge initially rejects his application for an adjournment, swears in the jury, and then on further application by the appellant at electronic bundle page 44 grants his application for an adjournment. So, my lord, we then move to day 2 of the trial, where we have Mr. Munro appearing. And I accept he does not mention any need for an analysis of the documentation of the samples, but the trial judge's position is absolutely clear. There is to be no adjournment of this trial, despite every effort by Mr. Munro. And the outcome of that refusal, my lord, is that the victim, after an opening, is promptly called to give evidence. And where in 1993, some 6 years before this jurisdiction introduced the Youth Justice and Criminal Evidence Act, saying that an accused cannot cross-examine the complainant, but the decision of the trial judge gave rise to the inevitable, and we say unfortunate and unseemly position, that this appellant was not only required to cross-examine in person the alleged victim of the crime, but also her husband. It appears, and I say this perhaps against the interests of the appellant, it appears he did so quite adequately. He put to her various inconsistencies that he claimed were material, but efforts were obviously going on to obtain counsel. And at lunchtime on the second day of the trial, the judge, having said it would be the ordinary 1 hour, after the victim and her husband had given evidence, at page 97 of the electronic bundle, we find the introduction of new counsel, Mr. Cooper. We say the position was clear. the trial judge was going to proceed with this trial come what may. Mr. Cooper himself doesn't in any way seek to apply for further adjournment. The applications for analysis of original exhibits which could have been postponed, we submit, would have been fruitless. The DNA was first used in a criminal trial in 1987 in this country, and of course at that stage in 1993, and since then, the science that we're considering has advanced considerably. So, my Lord, that's the background of the trial. Our grounds are set out in our case at page 467, starting at page 467, and they are, in effect, fivefold, because I don't propose to submit to your lordships anything about the failing to withdraw the case in the light of the DNA evidence. We say, in the circumstances, the fact that DNA samples were not provided to the defence deprived the appellant of a fair trial. And then we make four separate points, in effect, about the manner in which the case was dealt with. And can I say this? The first point is the core point of this appeal. The rest is, if I can put it this way, is make weight inevitably and adversely affected the appellant by reason of the manner in which the trial judge had dealt with it. So, my Lord, I move to the ground on the failure to provide the samples. The appellant, both at committal and at trial, have been seeking to have the core samples, namely the DNA, of the tissue analysed. We say that is clear from the short summary of the committal proceedings. If one goes to 451 of the bundle, the charge sheet The charge sheet has notes upon it, and one can see it being referred to, and we'll come to the reference, by the appellant during the course of his submissions upon the legality of his committal, which are to the front of the bundle. But can I take your lordship to this and identify...
Hang on just a moment. This is the supplementary.
I'm sorry, I have it all in one electronic bundle.
We got this later on, I've got it.
It is page 451, the core, yes, but it starts at page 450 yes, and goes over to page 452. And one can see certain of the dates and entries. I'm afraid I'm unaware of how this document looks in the original form and whether these are pages or whether it continues as a longer page, but I assume that these are 3 pages. It may be 2 sides of the same document and a second page. So we commence on page 450, and we can see references to the going up that page throughout 1994, starting on the 29th of April of 1994, at the bottom of page 450, going into June, and then into what appears to be the core period of the committal proceedings on the 23rd of August of 1994. And then over the page, we come down at page 451, again the reference to the 23rd of August, the prosecution closing, the 26th, there being a no-case submission by Mr. Hilton, the ruling being...
Mr. Hilton is of counsel.
Is a counsel,
He's
yes.
represented.
It represented him, but I think only for that portion of the committal proceedings. And then the appellant asked to call witnesses. There's reference to defence witnesses, it being adjourned for hearing of defence witnesses on the 26th of August. And then we move into November and February, and then there's a reference at the bottom of the page here on the 27th of March of 1995, stood down at 2:30 p.m., defendant further remanded, mentioned samples, further remanded. And that's what is referred to, my lords and ladies, when one goes back to the appellant's submissions at page 28, the electronic bundle, at page 28 of the electronic bundle. And perhaps I can put this into context. The appellant is seeking to say that the magistrate, in fact, committed him earlier on the, I think the 23rd after the no case submission, and that therefore the committal of him has been unlawful. And he goes through that submission, and it's useful to just start at page 27 of the electronic bundle, where the appellant is referring to a record and referring to the 26th of August, which we can see if we kept a finger in page 451, is one of the dates referred to there, as seen in line 18 through to 21 of 197, and he's obviously looking at some record of depositions. I had wished to reserve calling my witnesses, but I, in fact, on the next day, the 27th of August, asked that I instead be allowed to call witnesses at the preliminary inquiry. Permission to do so was then granted to me by the magistrates. Subsequently, the case was adjourned on the 27th of October for that purpose. He then goes on describing what had happened, and at the bottom of the page, in fact, your lordships, up until the time of my arraignment, I was still waiting for the magistrates' court to call me back so that I could be provided with a day when I could call my witnesses, a list of whom I, in fact, had already presented to the court. I had also, and we rely upon these words, as seen on page 2 of the charge sheet, so this is a reference to page 451, made a request to be provided with certain samples for defensive purposes. And that can only, we say, have been a clear and unequivocal reference, because there were no other samples in this case other than those relating to the tissue and the various reference bloods for defensive purposes. So he's making that position clear. My Lord, we've sought as best we can any supportive evidence for the position, and certainly since I was instructed, steps were taken so far as that was concerned. And you have a letter from my instructing solicitors expressing the outcome of the position, namely that Mr. Munro doesn't have a file and I don't think can recollect, and Mr. Cooper has not responded. Well, I'll come in a moment to the position so far as Mr. Cooper is concerned, but you do have an affidavit sworn by Mr. Saunders for what it's worth, and in paragraph 4 of that affidavit, he sets out that during the course of the preliminary inquiry, I made a request for the DNA samples in court. The magistrate instructed the prosecution that the samples or access to the samples were provided to me. 5, after my committal, Mr. Wayne Munro briefly assisted me with my matter. Prior to my arraignment, I understand Mr. Munro made an application to the Attorney General's office in relation to the DNA samples. So, my Lord,
I mean, there's no doubt that Mr. Munro was alive to this issue of the samples, but didn't seek fit to raise it when he was asking for an adjournment.
Well, on the appellant's account, he believes Mr. Munro is aware of it, but does not seek to raise it, and I accept that. But the appellant quite clearly is raising it himself when he's representing himself earlier on, and the judge, of course, has wholly set himself against any adjournment for any purpose. And of course that may be, as I understand it, and we know from the sentencing comments, this trial follows another trial which had happened, and there had been a 3-year delay in this coming to trial, no doubt because of that other trial.
Yes, I see.
My Lord, the most effective and only way to challenge this evidence as to the DNA was to have an expert and to be able to cross-examine the prosecution expert with the assistance of such an expert, based upon a detailed analysis of any examination which had occurred and tests which had been done. It's quite clear that these samples were in the possession of the police at all relevant stages when, in our submission, the defendant was requesting them. My Lord, they were sent to Mr. Howland, who was based in the United States of America. His evidence, my Lord, Kevin Howland, starts at page 142 of the bundle and goes all the way through to page 187 on the DNA. He says his evidence was that after February of 1994, all the items were sent back to Chief Inspector Ferguson. And Chief Inspector Ferguson would have had these items in his possession. And just to give your lordships the reference for that, that is at the electronic bundle, page 161, 30 to page 162 at line 27. And he's making it clear that it's returned. Chief Inspector Ferguson himself confirmed this at trial. He was called, and his evidence upon this matter is at page 210 of the electronic bundle. He stated that having received the tissue on the 23rd of June of 1993, the day of the assault, he received various, and that's at EB 210, line 12 to 25. He received various other items on the 23rd of August, and the 23rd of August 1993 is a significant date. That is the date that the appellant was arrested on the other matter, and the blood sample was taken from the appellant. It was for those other matters that this appellant was sentenced to 25 years, and this jury knew that some other matter existed, for when the officers of his arrest were called, they knew he was in custody, they knew he was taken from custody, and they asked the pertinent question, can we be told why he was in prison at the time? And they were told bluntly by the trial judge, no, you can't. How it and why it was dealt with in that particular way, I know not. But my Lord, the defendant's blood was handed to Chief Inspector Ferguson on the 23rd of August 1993, and he sent all of the items off, having given a preliminary examination on his evidence of the tissue, detected that there was semen on the tissue, he said. He sent them all off to the FBI on the 15th of October 1993, where they came into the possession of Keith Howland some days later for DNA analysis. And Chief Inspector Ferguson then confirmed that they came back to him in February 1994, and he does that at electronic bundle line, page 213, at line 7 to 10. Thus, the tissue, the samples, and no doubt the notes and evidence relating to the examination by Mr. Howland would have been in the possession of the Bahamas police from February of 1994. The centrality of the DNA evidence is simple. There was, in fact, no evidence against this appellant without it. And yet the case for the accused was alibi. He had named his alibi witnesses in front of the jury panel which was to try him. He had named them in front of the justices, and in the brief statement that was led in evidence at the conclusion of the prosecution case to the justices at, let me just find it, at after Mr. Ferguson and before the defendant's called 225 or thereabouts, it's read to the jury. His alibi is that he is at his father's shop, and he makes that clear. So, my lord, I come to, with that tracing of the background, I come to our first ground of appeal. That we submit there has been a gross failure in disclosure. There was at the time, and remains in the Bahamas, no statutory disclosure regime other than at common law. In our case at paragraph 3, my lord, we obviously rely upon the core authorities on disclosure, Brown and Ward at paragraph 4. My lord, I do just very briefly take your lordships to the statement in Brown at page 496 and 497, so that the court can have in mind the common law duties. Brown was the House of Lords post-dating Ward, and the passage which starts under the heading the common law duty of disclosure and concludes over the page, summarizes the key authorities from the start and cites passages from Ward, which we seek to summarize in paragraph 4 of our case. We would emphasize, and I'm at the bottom H of page 497, we would emphasize that all relevant evidence of help to the accused is not limited to evidence which will obviously advance the accused's case. It is of help to the accused to have the opportunity to consider all the material evidence which the prosecution have gathered, and from which the prosecution have made their own selection of evidence to be led. They then go on to consider Keane and set out the core principles which are now to some extent encapsulated in the statutory regime that we have in this country. Ward is particularly pertinent so far as scientific cases are concerned. Ward, and I take your lordships to the cited reference at the electronic bundle at page, I think I've got a note wrong here, 568. Conclusions on ground A, material non-disclosure. it's necessary to consider the impact of the legal rules governing the disclosure by the prosecution of material scientific evidence. And that's why this passage is pertinent to this case. An incident of the defendant's right to a fair trial is a right to timely disclosure by the prosecution of all material matters which affect the scientific case relied on by the prosecution. That is, whether such matters strengthen or weaken the prosecution's case or assists the defence. And then they go on towards the end of that paragraph to cite Leyland. The importance of this evidence was twofold. It was not only, that is, the DNA evidence in this case, it was not only the link of the defendant to the tissue, but also of the complainant to the tissue. Either link was possibly susceptible to challenge on a proper and careful analysis of the material. For example, and I simply say this by way of highlighting, Blackstone's at page F19, paragraph 29 of the current edition, says it's well known now that mixed DNAs can be problematic. I can't say anything about this DNA sample, but the failure to place the defendant in the position where this material was subject to analysis and the work of Keith Howland subjected to careful analysis meant that this defendant was left with this evidence being cross-examined by a counsel, Mr. Cooper, who had only been instructed the previous lunchtime, and in whose cross-examination, which occurs between page 174 of the electronic bundle and 183, he did not even call for the expert's notes. A reading of the cross-examination indicates that counsel was left effectively with the high point of Mr. Howland's evidence, saying that he could not make, and I'm here citing from page 180 at line 5 to 11, he could not make an absolute identification as he could with a fingerprint, but the possibility of someone else, he said, is less than 1 in 100 million. And that was the thrust of what the defence inevitably in this kind of position was left with. Even with that, there must have been something which the jury obviously felt some unease about. I simply say that because having heard the alibi evidence called for the defendant, although having said when they purported to return their verdict that they were unanimous in the verdict that was to be returned, when they were expressly asked about their numbers, they had unanimously acquitted the accused on count 2, but actually only convicted him on this rape by a majority of 8 to 4.
Which is the minimum that's allowed in the jurisdiction.
The minimum that's allowed there, and of course that's significantly greater than that could be allowed. We say the alibi witnesses, if that is the position, must have been impressive, or at least some of them were. This is an account that the accused had put forward. Central to his case was the need and the capacity to be able to attack this science that had given rise to this analysis. The samples from the accused were taken on the day of his arrest for the other matter. One doesn't know whether there are issues of contamination or not that could have been examined or would have come up on the notes. One knows absolutely nothing about it. All one does know, and I don't make any criticism of Mr. Cooper because he was in a completely invidious position. He had a trial judge who was insistent on finishing this trial within the week, wanted the jury out as soon as possible, and therefore effectively does what he can, which is say, well, members of the jury, how can you be sure that it's not the 1 in 100 million here that makes... Our submission is, in a case like this, there can be no fair trial without the grant to an accused of the right to have his own analysis done. That right was denied in this case, and therefore we say this conviction is unsafe. On reviewing our case in formulating these submissions on this matter, I was tempted to say to your lordships that certainly when one has a jurisdiction at a time when there is no funding, there is something for defence, and it's quite clear what's happening here is the father is running around with what cash he has to try and get a counsel in. When there's no funding for that, for a case to be so dependent on core evidence that effectively cannot be analysed and is not handed over, we wonder whether in fact it should be a positive duty in these kinds of circumstances. In a disputed case where DNA is absolutely central, can a fair trial occur if the accused has not been provided by the state with the means to have examined, tested, and to be advised upon the DNA evidence by an independent expert witness? Unless, of course, it could be shown that it's been positively waived. Now, I say, of course, that's only on reflection, and it's simply a start.
But I mean, I think, in effect, you're putting it in a way which means it actually doesn't matter whether he requested. I mean, you're in a slight difficulty because although there's suggestions at the point came up, there's certainly nothing to suggest that it was actually pressed by counsel. You're saying that doesn't matter.
Well, my lord, we're saying that when we are confronted with the position where you have a trial judge who's persisting on going ahead and making it abundantly clear that he's persisting on going ahead, Mr. Cooper obviously did what he could, but even then he didn't go for the notes, as it were, to see whether anything...
Your submission now is that really that doesn't matter. This was so fundamental.
It is absolutely fundamental in a case such as this. And then when one moves, and I'm beginning to run out of time... Yes. I'm reminded by my junior, when it's clearly an issue. And it is clearly an issue.
I mean, this was fundamental to the whole case.
It's absolutely fundamental to the whole case, and it's clearly an issue and clearly disputed. And therefore we say he is requesting, he's not getting.
Yeah.
But I do go further and say to your lordship, well, actually, if one reflects the reality of this kind of situation. So, my lord, I then move to how the trial judge dealt with this, and as I'm running out, my lords and my ladies, and as I'm running out of
yes, well, we've read
time, my lord, but can I just very briefly say this? On paragraph 10 of our case, I make no submissions. On paragraph 11, I want to say nothing about inferences, but simply to draw to your attention the direction of the trial judge at the electronic bundle, page 337, on the burden of proof, where he told the jury rather extensively what reasonable doubt did not mean. He said it did not mean beyond a shadow of a doubt, did not mean doubt based on a speculation, did not mean a fanciful doubt, did not mean hatched in your mind with entirely no connection, a doubt hatched in your mind with entirely no connection with the evidence, and that's at line 19.
Sorry, the page again, please.
The page is EB 337.
337, thank you.
And my lord, it's in that context that we invite you to examine what is put as a slip of the tongue, where he actually reverses the burden. Yeah. It's not beyond reasonable doubt, he says, at page 342. Yeah. Now, I quite accept that it could easily be a slip of the tongue, but my lord, in the context, and my ladies, in the context of what he's already said about it, it is the most unfortunate of errors. My lord, if one then moves to the Mears and Wood, and we have cited in our argument the relevant passages from the authorities, the judge, in his summing up, became advocate in the cause of the prosecution. I rarely, at this stage, can do no better than the way it is put by Mr. Thomas in his drafting of our case. The summing up of this evidence at electronic bundle 342 involves repeating 3 times in one paragraph the 100 million reference and adding to it a gloss that wasn't contained in the evidence. And my lords, I'm really at the penultimate page of our case. A gloss that was not contained in the evidence, remembering that it is more than 100 million people who would have had to be in Nassau at the material time.
He said it is one in more than 100 million people who'd have to be there.
Yes.
So what he's saying is the other person with the identical DNA would have to happen to be in the island at the time.
This is a trial judge entering the arena of the advocate. And we say that is repeated again in how he summarized the alibi evidence. You have against that the damning evidence of the DNA profile found on a piece of tissue at the scene at the time. And then he twists the knife, if I can put it that way, one final time, qualifying his direction on the burden of proof, even again talking about you are being asked to consider 1 in more than 100 million as being without reasonable doubt, to the extent that you feel sure that this accused was the person who perpetrated that act. And indeed, that was the argument that was left to this accused, because what we say was a failure to disclose and deal with this matter properly and fairly. So, my lord, those are my submission and my ladyship's, and I apologise, Mr. Thomas has persistently sent me notes saying, it's lords and ladyships. So I do apologise. And no disrespect was intended
really
at all. It
doesn't matter, as far as I'm concerned.
Thank you so much. Mr. Thomas, do you want to add anything? Right, Mr. Beddingham.
Thank you, my lords and ladies. I'll just start then with the point about the request or alleged request for samples. The first point, which I know your lords and ladyships are fully aware of, is that there were full committal proceedings in the magistrates' court, and that included the evidence of Mr. Howland, the FBI forensic expert. That is clear from the magistrate's docket, as he's listed as one of the witnesses there. But it's also clear that he was that he adduced in the magistrate's court what they call the auto radiographs, the X-ray films that contain the final DNA analysis. So those were tendered in evidence in the magistrate's court in 1994.
Sorry, where do you get that from?
So that's at page 170 of the electronic bundle. So this is actually during cross-examination in the Supreme Court. So Mr. Cooper, so page 170 at line 17, Mr. Cooper asks Mr. Howland, can you tell us why the duplicates were tendered at the magistrate's court as opposed to the original? And he's referring there to the duplicates of the auto radiographs.
Sorry, the auto?
Auto radiographs. That's, I mean, I don't pretend to be an expert on how it works, but basically Mr. Howland says that the final 6th stage of the DNA profiling is to put the results of the DNA profiling onto these X-ray films, which are shortly referred to as audio rads. He then creates exact duplicates of the audio rads, keeps the originals in the FBI laboratory in the States, and then he adduced at trial the duplicates, in the preliminary inquiry, the duplicates. So just to be clear, because there's some rubbing of two issues together, the alleged request made by the appellant was in respect of the DNA samples.
Yes.
What is clear is that there would have been led at the magistrate's court, presumably the final report of the expert and his DNA profiling slides. So they could have been obtained and independently analysed. But certainly, in any event, by 1994, and the preliminary inquiry took place on various dates between, I think, April and October 94. And then with the ruling in 1995, certainly for some 18 months or longer before the Supreme Court trial, he would have known exactly the evidence that was going to be led against him and what he needed to get in order to prepare for his trial. So,
I mean, how do you say we should interpret the record which says of the 27th March 95, which quotes mentioned samples?
well, just looking at that document alone, I would say that there was a mention of samples, but it's true that looked in context, there appears to have been some general request, or a request in general terms, for the samples. But, first of all, that wasn't followed up, it seems, in any meaningful way or at all between then and a trial some year and a half later.
Can you just help on that record at 451?
Yes.
What does the either JPO or FPO stand for? Last line of 451, please.
Wanted,
It's not the only mention of it. There's one further up the page as well.
I don't know.
Adjourned to 3595 and then F or JPO.
I don't know.
No.
It might be that my learned
And it's
friend-
there halfway up, 2 p.m., 17/11/94, 2 p.m., whatever those letters stand for, defence.
The prison.
But that's for the purposes of?
Yes.
Purposes of.
That would do it.
So remanded, adjourned to the 3rd of the 5th, so it could be for the purposes of mentioned samples.
Yeah. And then the next entry is over the page, and it is committed.
Yes.
So what became of the May hearing, where it was going to be, we don't know?
We don't know. But as I say, the real question is whether these... It's one thing mentioning in very general terms, well, I'd quite like the samples. And at that time, he was represented by counsel, Mr. Hilton. I know my learned friend said that Mr. Hilton only came towards the end. I'm afraid I don't have a reference for that. But
Hilton was there and made the submission.
Submission, but we don't know whether he was.
That's in August, and this is in March the following year.
But we don't know whether he was represented throughout, or it's an open question. But in any event, certainly at the prosecution close, by which time.
But it looks as though at the passage at page 170 that you've drawn to our attention,
Yes.
that the appellant was represented by Mr. Cooper at that time.
That's in the trial.
That's in the trial.
I'm sorry, that's
No, I think the
quite
Hilton
right.
is mentioned only on this occasion, I think, and
Quite right.
we don't, and unfortunately, the affidavit from Mr. Saunders doesn't help us, I think.
Certainly, at the close of the case before the magistrate's court, he was represented by counsel.
Yes.
And if he was chomping at the bit, if I can put it like that, to get hold of the DNA samples at that point, one would have thought he would have spoke to his counsel about that, and then subsequently spoke or took legal advice in the year and a half between then and the beginning of the trial.
So was he represented by counsel throughout the committal proceedings?
We don't.
I don't know. Or because the only record we have is that Mr. Hilton made submissions in closing. So I'd rather assume that meant that Mr. Hilton represented him throughout, but I'm afraid that was purely an assumption.
Yes, it's odd. I mean, in his affidavit, unfortunately, it simply says, I made a request for the DNA samples in the course of the magistrate's court hearing.
Yes.
It doesn't say where Mr. Hilton came in or what.
No. And of course...
And of course, we have also on page 28 of the bundle, our attention was drawn to him at the trial, saying that he had as seen on page 2 of the chart, made a request to provide them with
Yeah.
certain samples.
Yes, and I will come in a moment. Obviously, I don't know how much of the transcript the lordships and ladies have waded through, but it is clear if you look at that passage where the appellant represents himself. I mean, he's very articulate, intelligent, forthright, and in my respectful submission, if he really was concerned about these samples, it's pretty unlikely that he wouldn't have raised the point with counsel. And of course, the point being that it is not necessarily in a defendant's interest to procure a second expert report if he did the offence.
Well, before you move on to that, can I just ask you again about the adjournment to the 3rd of May?
Right.
I mean, it's not entirely clear from the copy whether there's a break after FPO, but if it means adjourned to the 3rd of May 95 for the purpose of mention of samples, then we know nothing about whether such a hearing took place. Is that right?
Correct.
And on the same date, on page 3, he is committed to stand trial in the Supreme Court at next session.
Yes.
So the trail runs out.
Yes.
Yeah.
And we don't have any, I think the appellant refers in his grounds of appeal to this court, which I believe he drafted himself, to an order having been made by the Magistrates' Court, but we don't, there's no evidence of that, or evidence of an application having been made to the Attorney General's office.
Talking about the Attorney General's office,
Yes.
we are told in his affidavit that Mr. Munro briefly assisted me. Prior to my arraignment, I understand he applied to the Attorney General's office. And we know from the electronic bundle, page 13, that the accused was arraigned in January of 1996. That's what he said himself at the bottom of that page.
Yes.
So is this the same Mr. Munro as who came in briefly when the matter was in front of the judge again
I don't know, but probably.
later on this?
I've only ever heard of one Mr. Munro counsel in the region, but I think so. Sometimes you get father and son duos. I don't think this is. I don't know.
So the Mr. Munro who we see making his brief appearance before he had to go back to the other court may be the same Mr. Munro.
I believe so, and I think he's since been, since asked whether he can remember, and I don't think he can. I mean, this all obviously happened donkeys years ago, which doesn't help. But the general submission on this point really is that if he was serious about getting the samples, we would have seen from this appellant, if you look at the way he behaves in court and the way he puts his case forthrightly and articulately to the judge and then cross-examines the witnesses, this is not somebody who would have made a general request to the Magistrates' Court and then done absolutely nothing about it, gone through an entire trial, most of which he was in fact represented, and not once said to his counsel, look, I want these samples, I've been asking for them for years, nothing's happened, this is all unfair, and counsel not say anything. And the point I was about to come on to before my Lord Jones...
Yes, sorry to interrupt.
No, it wasn't a criticism, was that it is not necessarily always in a defendant's best interest to go and procure a secondary report. Because it seems to me that, of course, if a defendant asks for the samples, and this is also another point about requesting samples, this is not a statement or some other piece of general evidence. It is evidence that must be kept in laboratory or at least sealed conditions so that it can't be contaminated or tampered with. So it's no good actually just asking, oh, can I have the samples, please? And then you hand over a dirty tissue to the defendant and say, go off and do what you want with it. Obviously, what you have to do in reality is get your attorney to say, we've got an expert, let's agree so that we can all be sure about the chain of custody and that it can't be contaminated, can't be tampered with, and then the police will hand it over to the expert. But of course, once you've done that, then unless somebody tells me there's some rule of law I don't know about, which is always possible, but once you've done that, the police can then be cross-examined about that. Well, what happened with the sample? Well, we handed them over to the defendant's expert. Did you? And then the defendant is cross-examined about that. Where's your expert's report? Oh, I don't want to talk about that. Right. Well, then you're in trouble. So I'm not saying that is what happened. I'm just saying it's not necessarily the case.
Is that right that it would be possible to cross-examine the defendant on why he'd not produced a report?
It would be, did you say?
I know.
Well, I don't know anything that would stop. I mean, if the police officers were giving evidence about what happened to the samples, and the question is asked, well, I had them in CID, and then I handed them on to an expert who said to be acting on behalf of the defendant, and then no expert report is produced by the defendant, then if that information is before the jury, it could be damaging. That's
Why would that statement be volunteered by the prosecution witness as to what had happened to the samples at that later stage?
Well, he was asked questions. It's a risk, isn't it? I mean, he was asked questions during examination in chief, and a quite open question about what happened to the samples, where are they now?
Yes, but that was at an earlier stage. That was before the FBI expert.
Well, and when they were returned to him. He was also asked questions about when the samples, when the report, when they were returned to him, where they were kept once they were returned to him. So it's perfectly possible that evidence could come out. I'm not saying it's a high risk, or I'm not making any particular judgment. I'm just saying it's not necessarily the case that it is without question of benefit for a defendant to get a secondary analysis of DNA. Anyway, the fundamental primary point is that there was never a proper request made for it. Request in general terms doesn't cut it, because for the reasons I've said, you actually have to make arrangements for the handing over of this evidence into a controlled environment.
Yeah.
Relatedly, I mean, on the case law, the Crown and Brown in particular, that is a case where the prosecution withheld relevant evidence. So we are there talking about an obligation on the prosecution to disclose the existence of evidence which could have assisted the defendant in those proceedings. We are not in that territory in this case. There is no question at all in this case of the prosecution having withheld evidence or failed, kept it under wraps. The existence of the samples and their later analysis was led positively in the Magistrates' Court and in the Supreme Court. The complaint, rather, is much narrower, that when I asked for the samples, they weren't handed over. Well, you have to follow, in my submission, that request up with a sensible means of actually passing these samples over, either to an expert or to some other controlled form of storage. Brown concerned a very different set of facts. In that case, the two witnesses gave statements to the police originally. Those two witnesses weren't used by the prosecution, so the defendant called those two witnesses. And then when those two witnesses gave evidence during the trial, they both said things additional to their statements which caused real doubts as to the credibility of their evidence. And the police knew about that additional evidence that wasn't in their statements and didn't disclose it to the prosecution, didn't disclose it to the defence. So, of course, you're in a completely different situation here. There's no question of non-disclosure. If I can use a sort of civil terminology, which is really talking about inspection, not disclosure. There's no question of the prosecution holding anything back. There's nothing on the file to suggest that the prosecution, in this case, refused to provide the samples. Rather, it's a very generalised request at most was never followed up. Well, does it, in my submission, lie in the mouth of an obviously articulate and thoughtful defendant to say nothing about this for 2.5 years, nothing about it all the way through a trial, and then before your lordships say, well, it's all terribly unfair because I didn't have the samples?
And you also make the point it's not at all clear what he was going to do with the samples had he got them.
But he knows what he should. The only thing you could do with the samples is to get your own report.
Yeah.
And we know that because in his grounds to your lordship's board, This is at 399, please, page 399 of the bundle.
Yeah.
Well, paragraph... Right, so paragraph 16. Immediately upon apprehending the scientific nature of the evidence upon which the prosecution was relying, i.e. DNA evidence, application were made by your petitioner to the court and the Attorney General's office, respectively, for him to be given either samples or access to the relevant materials to enable his having independent analysis conducted in regard to the same. So it's not like the appellant didn't know what he would have done with the samples, but that cuts two ways. He would also have known, therefore, that he needed to instruct an expert, and that expert would communicate with the police and say, hand over the samples. And that just didn't happen. Whether that was by design or just through advice or whatever, we don't know. Then at paragraph 17 on the same page, please.
You're saying it didn't happen, but there's certainly no assertion that an expert was instructed to receive such samples as the Attorney General made available.
No, he certainly would have had at least 2 years and a bit since the beginning of the committal proceedings to get that done.
Yes.
And
Paragraph 17.
17, halfway down, sentence beginning, such was vital to the proper preparation and presentation of your petitioner's defence. He was unfairly ambushed by the prosecution, who, absent such having been first put in evidence during the preliminary inquiry. Well, that's just wrong. It was put in evidence during the preliminary inquiry. We know that because A, Howland's on the list of witnesses, and B, there was a reference to him being crossed. So the ambush point, for those reasons, doesn't work. Just coming back to one or 2 points I'd like to respond to from the oral submissions. In terms of the judge's desire, as it were, to push on with the trial and not to grant the adjournment, I think that is evident, but could I ask your lordships to turn up page 49? Now, this is the court's response to Mr. Munro's application to adjourn. On the 8th of October. And the court says at line 11, and he appeared, namely the appellant, also on the 1st of April, also on the 1st of July, and also on the 27th of September when it was adjourned.
Sorry, you're reading from page
49,
line.
And then at line 11, please.
Thank you.
Thank you. Just to make the point that although this appears to have been brought on fairly quickly, it had been, it looks like, there had been previous mentions and then adjournments on previous occasions. So it's not like issues weren't bubbling away. And what the court is complaining about is that the appellant on the 7th of October, which was meant to be the beginning of the trial, turned up and made very extensive submissions as to why the trial shouldn't go ahead because of an irregularity, an alleged irregularity in the committal proceeding stage, but had said that he was only going to secure counsel if he lost that application. And I think what the judge is saying here is rather taking the view, well, that's not a very sensible way of proceeding. I'll just say that for context. You know, it's not that this hearing would have been completely out of the blue. And then, as I say, if your lordships read sort of pages 2 to 28 of the transcript and the appellant's submissions about the constitutional challenge and various other challenges, he obviously basically knows what he's doing.
Yes.
To some point. Can I just see if there's anything else or other points I want to make on the samples?
Could I just ask you about the appeal? There was an application made to appeal against conviction and sentence. We've got the application. It's in very general terms. There's no reference there to DNA.
No, I don't know what the content of the. I mean, they just there's a generic form that they fill in, but there's nothing. There's no submissions backing that up.
There's a form which is filled in, but there's a manuscript addition to it.
Where's that?
Towards the end of the bundle.
Yeah, 300 somewhere, is it?
It's 360.
Thank you.
Well, 3
Yes. Yes, exactly. That's what I've.
It's 360, yeah.
It's just the generic. See in quite a few of these cases. Yes, I mean there's no.
And then we see the result on 361.
Yes, but we don't know what else.
But do we know what happened? Do we know whether there was any sort of a hearing, whether there was a leave requirement?
The appellant says there was no hearing, and that was one of his complaints.
Yeah.
That it was just dismissed on the papers, but not able to. I'm not able to assist with that.
But as far as it goes, no point was taken on the failure to provide samples.
I don't know.
It just says, under all the circumstances of the case, it was unsafe. So
Yes.
we don't know what.
Don't know.
There may have been further
There may have
documents,
been
but we
further
don't have them.
We don't have them, and we did try and find out, see if
Because,
there was
I mean,
a transcript somewhere of a hearing. We couldn't find anything.
yes, but because one could hardly dismiss on the papers an appeal based on such a general statement.
Right.
Yeah.
But he says in ground
could.
one that he had filed some more grounds at 395 in the bundle, doesn't he?
Yes.
Yes.
In replacement for the original grounds, and I presume that these were the original grounds.
That would be normal. You would put that in to save time, and then.
And then he says in paragraph 2 at 395 that he's put in some more.
Yeah, I'm afraid I just don't know. I'm not able to gainsay that one way or the other, I'm afraid.
Right, well, thank you.
Right, so I was just looking to see if there's anything else I need to say on samples. No, I don't think I do. So I can move on to the last point in terms of summing up. Obviously, I would accept that, in general terms, the trial judge is to leave questions of fact to the jury, and giving strong opinions on questions of fact is obviously a dangerous thing to do. However, I would respectfully separate, first of all, the judge's references to the 1 in 100 million evidence and the alleged gloss, because in the case of the 1 in 100 million, whilst of course it was open to the jury in theory to reject that evidence, not just to reject the fact that it could have been, it could have been another person on the island at the time, but also to reject the basic point the basic analysis and evaluation reached by the expert. In reality, in the absence of any expert evidence challenging Mr. Howland's account, it's pretty slim room, really, for the jury to
Yes,
reject.
but I mean, if it had got to the stage where you've got on the one hand the expert's evidence, and the 1 in 100 million and so on, but on the other side, if the jury had thought that the alibi witnesses were totally
Yes.
convincing, so, I mean,
Absolutely.
presumably they'd have had to acquit, wouldn't they? if they-
And 4 of them probably did think that.
Yeah.
But what I'm trying to say is there's nothing wrong.
And you know, arguably what one's struck by is that the judge comes back to this 1 in 100 million, and particularly in having referred to the alibi evidence, he then again says against that is this damning evidence, and isn't that possibly entering into the list rather more than he should?
Well, in my submission, there must be, if a judge does enter into the arena and say things about the facts, that must be more of a problem in some cases than in others. And the cases cited, for example, Mears, are cases where judges have expressed very strong views on whether somebody's oral testimony should be accepted.
Yeah.
Where we would all accept that's really a very obviously a matter of perception and so on, real jury stuff. But it is, as a matter of logic, going to be less problematic for a judge to express views where there is effectively unchallenged findings of an expert.
Yeah.
And the 1 in 100 million is what the expert said.
Yes.
So what's wrong, I say, and the judge saying, well, look, that's what the expert says. When he was cross-examined by Mr. Cooper effectively said, well, look, that may well be the case. However, it doesn't necessarily mean that there isn't another 1 in 100 million in the Bahamas. So it was never really questioned. So in other words, the complaint of the appellant must be narrower. It must be on the repetition of the 1 in 100 3 times. Well, I say, well, given that that's the most important evidence, that's hardly surprising. The judge doesn't reference it in sort of hyperbolic or overly sort of advocacy. It's not an advocacy type. It is.
We've read it and we can take our own
Yes.
view. Thank you.
The judge at 335 does give the standard direction in relation to the facts for you and the laws for me. Don't be influenced by any view I express as to the merits of the case if he doesn't find favour with you.
Yes, but also, can I just take your lordships to 2 more references to make up this ground, and then I will stop. So, if I could ask you please to turn up page 179. This is the cross-examination of the expert by Mr. Cooper, the appellant's counsel, and what he says at line 13 refers there to the prospect from the black race of finding a match would be 1 to 100 million. Answer, I would have to look in more than 100 individuals. Now, while that may be the case, so there is that possibility of that stain not coming from Saunders. Yes, that's accepted. And then again at line 30 accepts there is a possibility, and then at lines 31 onwards, that's on the paper, it would have been one of those 100 million to the exclusion of Mr. Saunders. That is possible, yes sir. It's then put to the expert that actually, well, DNA cannot be considered an accurate or defined science that one can rely on. Well, I would not use those words, and he says basically, chats a little bit about that. Then at line 12, at the present, 11, at the present time we're not able to make an absolute identification, but we feel that this is strong evidence that it is this person as the contributor. Counsel then says at 18, I prefer to use and look at the possibilities. It's a possibility it could have been for someone else. Yes, sir. So it was during, these points were made during cross-examination. And then questions from the jury ask what might be the sort of golden question in terms of the alleged gloss, which is, well, effectively, although it's 1 in 100 million, that doesn't necessarily mean quite a few of those ones in 100 million might well be in the Bahamas at any one particular time. So that's at page 183, line 26. So this is the foreman, the foreperson, who strikes me very likely as being a lawyer. But anyway, so the foreperson asks quite a few questions during the course of the trial. Line 26 is, so just to clarify a fact, I mean a point. If you tested, say, over 100 million people, it's possible that the first person you test, their DNA may match a known DNA. Yes. And then the expert clarifies, I would have to go out and collect all these samples, and then I started testing each of these over 100 million blood samples. While I said that there is a possibility, you're absolutely right in that it could be the first sample that I tested, or it could be the very last that I tested. I don't know when I begin the test which one is going to match. So this deals with this point about 1 in 100 million in the Bahamas, just in case anyone's concerned that the jury would have been confused by that. It's obvious enough that...
yes, I mean, obviously quite intelligent questions being put.
Yes, and being put by a member of the jury, so almost certainly discussed in the jury room and therefore on the minds of the jurors when they reach their decision. Otherwise, I rely on my case.
Thank you very much indeed. Right.
Very briefly, 4 points. Page 385 of the bundle is another location where the appellant sets out the history in broad terms for which he contends at paragraph 9 of his original grounds of appeal. Paragraph 9, 385. Without his having been furnished with the samples of the evidence as had been ordered, your petitioner was purportedly committed to stand trial at the Supreme Court. In the interim, between the purported committal and eventual trial, your petitioner also had transient counsel Wayne Munro, who wrote to the Attorney General. So further confirmation of that. If you go back to the actual document upon which there is reference at page 451, I simply want to put a second interpretation on this, that this indeed, if interpreted in this particular way, would be compelling evidence that there was a request. What we know from page 452 is that on this date, the 27th of March 1995, he is committed. In other words, the justices or the justice is getting rid of the matter up to the court. Mention, of course, could mean two things, not just mention of samples at this hearing. It could be 3rd May 95 for purpose of a mention. In other words, a mention to deal with the issue of the samples. Yes. And that would make it very, very clear that what was happening was a request in connection with the samples, which never transpired and never took place.
Well, we don't know what happened, do we, on the 8th of May?
But what we do know is that by the time we come to trial, nothing's happened. And we don't, I completely agree we don't know what's happened, but we do know what the appellant is asserting, namely that he was requesting for that, and he's doing that on the very first morning of his trial.
Under these procedures, once the defendant is committed to stand trial in the Supreme Court, does that in effect end the jurisdiction of the Magistrates' Court?
I'm afraid I'm not familiar with that, but I would have thought that it does. If it's the same as this jurisdiction, it would do.
Well, it's odd then that one adjourns to a date beyond the date.
Well, my lord, I say that is exactly what happens in every justice court in this country. They're adjourned to an express date for first mention at the Crown Court. And that could be what's happening here. In other words, the justice is saying, well, you've talked to me about samples, but I'm not going to deal with it. There you are, you've got your first mention hearing. and that's the note that comes about. But, my Lord, we're in the realms of speculation.
We are.
We're in the realms of speculation. What we say is there is compelling evidence that there was a request made and nothing was supplied. It's suggested by the respondents that nothing would be gained or nothing might be gained by this. We say this is absolutely essential and central in any DNA case. That examination occurs, and indeed there can be no downside to the defence in connection with doing that. One can cross-examine on all sorts of points that may arise on it. One may get a response that indicates it's the same, but the position could be no worse than it was in this trial. In other words, absolutely everything to gain. One could never make the position worse.
Yes, questions of contamination, mishandling and so on would not be determined by getting the same result as the prosecution got.
No, absolutely.
Yes.
And there may be all sorts of other issues about the handling of the exhibits that come out from the notes, when exactly things arrive, what's actually happened with them, whether there are areas of contamination that could have occurred that could have given rise to the misleading sample, and all of that kind of area. None of it was explored in a case which leads to a 14-year sentence, and all of it should have been.
Well, could I just ask you again on the note in the at page 451,
Yes.
When it says, for the purpose of a mention about the samples, wouldn't the onus then be on the appellant, represented or not, to make his application? Because that's an application, that's an opportunity to get directions. And then the court could deal with all these matters like access, ensuring integrity of the sample, and hearing submissions, imposing a
It's
time.
interesting because if one goes back to paragraph 9, and I apologise for interrupting, he does appear to be saying that his impression was that his application was granted.
Well, I mean, that's very difficult to judge, isn't it? And a litigant may have misunderstood that from the fact there was going to be another hearing.
Yes, well, my lady, it's not satisfactory. And I come back to the fact that this is a trial that has occurred without any analysis and any defence assistance so far as this is concerned, pushed on by the trial judge. And my Lord, reference was made to Brown, and this kind of non-disclosure was said to be very different. But my Lord, I draw your Lordship's attention to what is said in Ward at page 586, which is... Sorry, I put down 586 and that must be wrong. No, yes, 568. I apologise. Ward at 568, where it is clear that the court in that judgment is making very clear the type of material that should be disclosed in cases such as this. An incident of a defendant's right to a fair trial is a right to timely disclosure by the prosecution of all material matters which affect the scientific case relied on by the prosecution.
But you would accept that you don't have to hand over a sample without an agreement, or at least, as to how it's going to be handled and who's going to have access to it, where it will be and how it will be conserved and all the rest.
Consideration of the realities of the position in the Bahamas with limited legal aid in connection with these areas and defendants who are facing serious allegations who don't have particular funding, it led me to make the submission which I made beforehand, that this is a really appalling position, that people could be being convicted on decisive and compelling evidence in relation to DNA, and yet not having, for one reason or another, the facilities provided to them by the state to get this tested and to be put at a position.
But that's a separate issue from the one I'm asking. I understand that point. I can see where you're going on that. But actually, this is within the judicial system, and the matter has been stood over to come on before a judge in the Supreme Court.
Yes.
That would surely... You would want to take the time of the judge for that sort of matter in order to iron out the practicalities about what's going to happen to the sample. I mean, if he's still... I know
there is some reference, and I just mentioned this, to the number of hearings there have been in the Crown Court for Mr. Munro when he makes his application. And when the judge lists to him, but this case has been in, and he says, this is,
You've seen that. I think we've got the point. I mean, the trouble is we're all faced with the fact we don't have very adequate records of what was going on.
It's page 49, I think.
Yes. My Lord, I have one final point which I wish to make, and that relates to what I'm going to call the final ground about the way the trial judge dealt with this. This was repeated reference to the 1 in 100.
Yeah.
And in Wood, my Lord, at page 597 of the bundle, there is very clear reference to exactly that position. This was, I don't know the number of times, but I think it's 6 or 7 or 8, the 1 in 100, with the gloss about Nassau and the gloss about it being damning. At
page?
597,
Yeah.
one should notice the degree of repetition in that passage. Not only is the point said twice to be important, there are 2 references to Wood clearing his head, 2 to his suddenly noticing the map, and 2 to the map having been forgotten, escaping his memory. This is the stuff of advocacy. And my Lord, my submission to your lordships is that this trial judge descended into that arena, and the way he dealt with this issue was the stuff of advocacy. And of course, why that might happen is commented on, I think, in Mears, where they say, of course, judges may be tempted to try and either strengthen a weak case or bolster a strong one, undermine a strong one, or what have you, entering the arena. That is what has happened here, and it further significantly, we say, to the lack of safety in this conviction. Is there anything else I can assist either your ladies or my lord?
No, apparently not. We're most grateful to all involved, and particularly those who are here pro bono. It's been an enormous help, and I'm very much conscious of the works being put in it, not only by council, but those behind. And the board will take time to consider what advice they will humbly tender to Her Majesty. Court is adjourned. Thank you very much.